Good morning, and thanks for joining us here on Condo Solutions. Monday mornings, we talk about things that affect you in your condo or your HSA. I'm Mark Breckville, local CPA and licensed community association manager, along with Peter Mullengarden, who's our attorney and has been practicing law in this area for a number of years and has been working on this. So we're here to help you out, but it is a community service program, so write down the number 220-9788, 220-WSTU, in case you want to call and ask a question, or later on on another show, maybe you want to call in here and ask a question. That's the studio number, so you can call 220-9788, 220-WSTU, and we'll be happy to get you on the air. We need something to call you, but we don't need your association, so we don't want to know who that is, because some people may, if they hear the association, they may assume that it doesn't apply. So we want to make sure they listen to the question, because it could be the very question that they have or very close. Also, we try to deal with the answer as well as we can, but we don't have your documents. So for us, we have to give you an answer based on common practice, your understanding of the documents, laws, rules, regulations, common issues. And so we can't give you a hard and fast answer sometimes. And for that reason, if you have something that, you need to go to court on, or you're going to take legal action on, you might want to sit down with somebody like Peter and ask them and let them look at your documents and specifically deal with the issue. So that he can give you an answer that may be closer, because as many of you know, the documents can change that answer completely. They can make it 100% different than maybe what you would originally think, because the documents have some language in it that overrides or makes it conflicting. So for that very reason, it's important that if you've got something that's that important, that you contact somebody like Peter directly. But for us, we're going to give you the best answer we can. We call them radio answers, but it's the best answer we can do. And we encourage you to call and ask the question. And we also encourage you to tell your friends about it, so that they can listen and ask questions if they've got it. Good morning, Peter.
Good morning, Mark. How are you?
Good. We've got our first caller this morning, so we'll go right to Eric. Eric, go ahead.
Good morning, gentlemen.
Morning.
I have a question dealing with changes to common elements, which seems to be a frequent question. We have a pool fence, 8-foot fence around the pool area that needs replacing. It's in bad repair. And one option we had, the fence company brought to us, was to go from a chain link fence to a very nice aluminum picket fence, which would have a longer life expectancy, as well as improve the aesthetics around the pool area. Would it be a change to the common element if you didn't go back with the same type of fence?
Okay. Mark, you want me to take this first?
Yeah, go ahead.
Okay. The answer is most likely yes. Although there could be one caveat to that, which I'll get to in a second. Basically, under Florida case law, a material alteration is when you change the form, shape, elements, or specifications of the property or any portion of the property in a manner which appreciably affects or influences the use, function, or appearance. So changing the chain link to an aluminum picket obviously is not going to change the function. It's still going to function as a fence, as a pool fence, but it will change the aesthetics, the appearance, clearly, in a appreciable manner. So that is a material alteration just on the face of it. Now, there are a series of cases, and this is the potential exception. There are a series of cases in which an association has been permitted to make a change, which is otherwise immaterial alteration, if the change is reasonably necessary to maintain, repair, or protect the property. For example, if you're having a problem with crime, and you need to put in a fence where there wasn't a fence before to protect the property. Other cases, we have a situation maybe where there's been some assaults or some other crimes, and it's really dark, and you put in lighting to make it better lit. That's a change, but again, that's okay. There's two famous cases where two associations had erosion problems. One put in or extended their seawall. The other one put in a rock jetty to help prevent the erosion. Both of those cases, even though those were alterations because they put in things that weren't there before, they were held to be maintenance purposes because they were being done to protect the property. Now, going back to your situation, you did say that the aluminum picket fence will be more durable, potentially have a longer life.
Right.
That may, I'm going to use the word may, because I can't swear, it may be sufficient to say that you can take advantage of, because there's another case where an association went from a Chattahoochee pool deck and they put in pavers, which obviously looked much different. On the face, it was an alteration, but then the arbitrator stated that since the pavers had a much longer life, they're much more durable, much easier to maintain, and you can pop them out to get to the pipes underneath and fix those and pop the pavers back in, that it was basically serving a maintenance purpose, not an aesthetic purpose. Here, you'd have to weigh as to, what is the difference in terms of longevity, in terms of durability, ease of maintenance, etc., comparing the aluminum picket to the chain link. May be enough to get by with this is for maintenance, not for aesthetic reasons. As I tell my clients oftentimes, if in doubt, get a vote. Because whether or not this is enough of a maintenance purpose as opposed to an aesthetic purpose, it's hard to judge that. If the aluminum lasts for 30 years and the chain link lasts for 5, well, that's a pretty big difference. If the difference is not as significant, I don't know.
Right.
But like I said, at the end of the day, if it's not something that's pretty obvious that it's needed for maintenance, repair, protection, the vote is always the more conservative way to go when you're clearly changing the appearance of the of whatever portion of the property that we're dealing with.
Now, Eric, one of the things too that might help with this to check with your insurance company to see if this fence, the new fence, would be insurable, whereas probably the other fence may not be. And so that could be a big difference too, because now you've increased the protection for it from an insurance standpoint as well. And that's a big deal because some of these things like fencing and all that kind of thing, landscaping, those things are typically not covered by insurance. And so when we have a storm, those become items that everybody has to pay out of pocket. So not only, like Peter says, is there may be the maintenance issue, but there also might be an insurance issue, which would then also potentially justify the switch to that type of material, that type of fence.
And I'm assuming that code permits both, because obviously, if you have a code issue, it's not a material alteration to comply with current code provisions. I'm assuming it's a bad word to use,
right.
But I'm assuming that the chain link and the aluminum picket are both code compliant, as long as they're built, to the right height and all that stuff. So, that's not unfortunately, the law is not always a black and white answer. If it was, all our lives would be easier. But that's the basic analysis of this kind of change.
Okay, I think that answered my question. So, yeah, I was looking at it from a standpoint of a durability issue where maybe you get, 50% more life, out of the fence.
And that may be the answer.
And again, that may be sufficient. I can't swear to it. It just really depends what the arbitrator would think. If that 50% durability is enough to say, you know what, okay, we're going to go with this because that's really a maintenance function, durability function, and not we just like aluminum better than a chain link.
Right. Okay, appreciate your answers.
Thanks.
Right,
Thanks,
thank
Eric.
you.
Thanks for the call.
Okay.
I think that's probably one of the most. I think that's probably one of the more difficult issues is these common property issues. Like this is the, because it does come down to that. And like I say, you get it's almost almost a facts and circumstances type thing. Specific facts and circumstances. Like in this particular situation, it's possible, depending on what the issue is. Is it going to be something that significantly reduces maintenance
No, I mean,
costs?
and in Eric's situation, I don't want to be too negative. It's just I can't, that may be sufficient. It may be sufficient that the chain link has 50% less durability than the aluminum picket, and that may be sufficient. It's just, it's just hard in that situation to give an exact definitive answer.
Peter, it's interesting because then you get into all these things, and it's really kind of crazy. But so what if you go from a regular chain link fence to a galvanized black? They've got these ones that have got the black coating on them, or the So now all of a sudden, what happens there? It's
same answer though.
Yeah, I know.
Same answer. Again, you're changing the appearance,
right?
Okay, but if the galvanized black whatever is something that's recommended, to protect the chain link, and something that that engineers and others recommend that you should do, as far as making sure that the fence is protected from rusting and blah blah. Then again, that's maybe or likely would be sufficient. But it's really a case by case analysis.
Yeah.
How much maintenance or protection advantage or benefit are we getting from the new material or from the different looking material or coating as opposed to the change in the appearance? Is it enough to overcome? Okay, this is an alteration, but clearly we're doing it for maintenance purposes, not for aesthetic purposes.
The along the lines of maintenance stuff, since we're on that subject, this is kind of a little bit different, but it's something that I wanted to talk about this morning because I've been dealing with it myself. And that is we have this new requirement, which I understand that there's some talk about backing off of, but this requirement that, and you can help me with this, Peter, on having a website for if you have 150 units or more, and it's for condos only, or is
condominiums?
Yeah, so it's just for condos. If you have 150 units or more, you have to have a website now, and that website has to have certain information on it. And so it's going to have, basically what it amounts to is it's going to have a member section, and it's going to have a non-member section because anybody could potentially access it. So I've been talking a little bit about what a bad idea that is, and the reason is for my purposes, the reason is security. Those things are going to get hacked right and left, and there is information in there. And so I know that there's people out there that are saying, well, we're not going to make it public for, there won't be social security numbers out there that are public. There won't be such and such that are out there that'll be public. Anything on your computer is going to be accessible by a hacker. That's basically where we're at in today's environment. And so,
well, you shouldn't put the social security numbers on there, period. Anyway, okay, because there's no reason to.
Well, what I'm getting at is that many associations are going to run these websites on computers that they are running their other data on. And my concern is not that they're going to make it available, and not that they're going to make social security numbers available, but what they are going to make available is anything that's available on their regular computer, accessible only by people in the office or by password protected documents or whatever. It's not going to be on the website, but they're going to get into it through the website. They're going to get into it and hack into the users there and get access to these files. And I'm telling you, it's amazing, Peter, where we are right now. I remember that they used to tell you that if you had a password that had just letters, and it was 8 characters or less or something like that, that it could be hacked in like 2.5 hours or something like that. And then they used to tell you that if you had letters and numbers, it was like a year or something like that. And then if you had a complex password that had numbers and letters and capital letters and symbols, that it was like 2,000 years to hack into something like that. Nowadays, you're talking about 3 to 4 hours to accomplish that with a complex password. So what that means is basically a hacker can hack into anything. There's actually machines that you can buy on the dark web. They're expensive, but you can buy them that will actually do this for you. I mean, anybody can get access to this. So this isn't stuff where sophisticated hackers alone, pretty much anybody with some money can get access to this stuff. So
Mhm.
I just think I'm just really going to caution our listeners that are implementing these things to to think about what else is on this website. And and if you're thinking about maybe putting it on a on a server that's accessing, that's being used for both your data, even if you've got a computer person that's doing that for you, you really need to look at whether that makes sense, because these things are going to be targets. The hackers are going to know they're easy pickings because the security's not going to be there. I remember a few years back, now this was, well, it was probably 8 or 10 years ago, maybe more than that. Now I basically had a cloud-based system that it was my own cloud, so you accessed it like it was a cloud-based system, and I had security on it. I had, spam filters and filters for all kinds of different things, and but even with all of that on there, um, someone had managed to get onto my server between, they hadn't gotten onto my server itself, but they had basically gotten between the server, access to the server, and access to the internet. The way it was set up, my internet ports were not, um, didn't have mechanical uh, protection on it, so those ports could be accessed through the software. And so I was sending out 3,000 emails a second or something like that. I mean, it was like ridiculous. I couldn't understand why my server was running so slow. And it was, now most of this was occurring at night, so we didn't even notice it. But they were sending out thousands and thousands of emails. And what it was is this is how all of this communication goes out. Some of it was not really that, it was just spam being sent from my computer, but other stuff was illegal activity, all kinds of crazy things that were out there, to the point that I was almost to the point that I was going to be blacklisted from any of the websites. None of the mail servers were going to handle me, because my IP address was considered a bad IP address. It was considered one that people were spamming and doing all kinds of things from. So it's this is we talk all the time about how condos are really a fairly big business. It's they have a lot of revenue, and they're these corporate entities, and yet they're run by volunteers who may have no corporate business experience. And this is an area where many of them will have zero experience with what's potentially going to happen until it does happen. And the state and some of these legislators are all worried about people stealing money from associations. Trust me, you can steal way, way more money easier through their computer than you can ever do it by being a property manager and trying to take it from them. That is easy money, and it's happening all the time right now. And so I just think that, I think it's a huge mistake, but I think that if you've got a website, or you're going to have a website to meet the requirements, you need to look very seriously at how you're setting that up. And in my opinion, if you're going to set that thing up, it needs to be isolated on its own system, that there's nothing else on there and you can't get anywhere else from it. And, make sure that it's completely segregated and isolated from from anything else you're doing, because it's going to be a nightmare, let alone the spam that's going to come in through that thing. Just as people spoof your email IDs and things like that, they're going to get that. They're going to use that to spoof you and hack other people, friends of yours, all kinds of stuff. I mean, this is just ripe for somebody to make a lot of money off of. The way most of these hackers do this stuff, including this ransomware, is they go in and they spoof somebody's ID email. What that means is that when it comes into your system, it looks like your email address. It looks like just like somebody friends of yours email address. And unless you run your cursor over that so that it changes and you can see what the actual email address is, it looks like you're getting an email from Mark Breckbill. And you say, oh, okay, he's my accountant. He's sending me a file. Oh, he sent me this. He sent me a copy of my tax return. It's a PDF file. I'll go ahead and copy that. So you download that. And next thing you know, that has got a file in it, which either plants some software or allows someone to get into your system and manually, steal stuff. But basically what they're going to do is they're going to put a program on your computer. It's called ransomware. And what happens is that it will become activated at some point. Initially, you won't even know it's there. You won't know that, you won't know where it came from or that it's even there. But it gets activated. It comes up. It's in what's called your root directory. That's the basic directory that controls your operating system on your computer. And it says to you, send us $8,000 in Bitcoin, or we're going to destroy everything you own. And that's exactly what they do. You've got a certain period of time to purchase Bitcoin and transfer it to them, which is untraceable. And if you don't do it, they wipe your hard drive clean. Everything you own, everything you have. You can't back it up because the file's still sitting there someplace and you don't know where it's at. So there is no way. At that point, it's buried, because one of the first things this stuff does is it sends these things out into different files so that all kinds of different files are corrupted, so that you can't take it off, so that you can't back it up and pull it out and find the file and take it off. Once you've got it, you're done. And so you either pay the $7,000 or $8,000 or $4,000 or $3,000 or $20,000, or you lose everything you've got, all your history, all your data, and everything you own. So I'm just, that's why I thought this was a bad idea, and I still think it's a bad idea. To the point that, I'm not one to really flaunt and say, we shouldn't follow the rules. But I'm pretty sure I would follow the rules as little as I could on this one. I mean, to the point that I'd only do what you're required to do. I'd make sure you don't do it on your regular computer, and I'd make sure it was protected. And if there's certain things that aren't available, I would consider them sensitive data, and I wouldn't make them available, including email addresses. I think email addresses are a problem if they're available or potentially on the server there. So I just think it's one of those kind of things where you've got to think really hard about what you're doing and how you're going to do it, because it could be a real problem down the road for you. And this is one of these areas too where some associations are taking the position that I know how to do this stuff, so I'm going to do it. I'll do it for the association, and they may know how to do. There's a lot of people now that know how to do some website stuff, but the security features are the issue. But anyway, we've got a caller. Roberta, go ahead.
Hi. This is unrelated to what you're talking
That's all right.
about.
No, good.
But this happens frequently when I sit and observe our board meetings on a monthly basis. And oftentimes a board member will say, well, our attorney says blah, blah, blah. And based on whatever that is, they make a decision. But how is the process of getting the legal opinion documented? I mean, we won't see in the record, in the minutes or anything, like a letter that was sent in writing explaining the situation or providing evidence to the attorney or even the letter back from the attorney. Sometimes the condo manager will state that he emailed the attorney about it or something. But it seems very vague, and then there's nothing in the minutes from a historical standpoint in the future to look back on to show how that decision was reached or what the attorney said, per se.
Well, I think part of
Well,
it,
that's a good.
and I'm going to throw it to Peter in a minute because he's the attorney. But I'm just going to say from the standpoint of a property manager, CPA type person, what happens a lot of times, and this is not always good, but what happens a lot of times is that we deal with these issues on a regular basis. So we may have contacted that attorney about this problem previously. So that's one thing. It may be that we've talked to that attorney. Now that can be a problem because laws can have changed. But a lot of times when a board member or a property manager is saying that, what has probably happened is that they have asked that attorney, the association attorney, that question either on this association or another one recently. And that may have been verbal. It may have been in an email. But a lot of times an association won't go to the full extent of a formal legal opinion because frankly, that's expensive. I mean, if Peter or somebody else is going to write a legal opinion on a subject like that, they're going to have to cite court cases and references. They're going to have to put it all together. It's going to have to go through their firm's peer review process to make sure that they're, that everybody's in agreement with it and that it's going to meet their requirements for rendering a legal opinion. Because of course, with a legal opinion, somebody's going to take legal action on it that could backfire on them. So,
well, I guess I probably shouldn't have used those words, legal opinion. But often at times it seems as if the board justifies a decision based on, well, our attorney has, said blah, blah, blah. But we don't know what the question was that they actually asked to the attorney.
Right.
Well,
how they justified it.
Let me just jump in here for a second. I realize that this is somewhat frustrating for owners or for members of the association. But the problem is that communications between the board and the attorney, both ways, whether board to the attorney or the attorney to the board, is privileged. It's privileged and confidential, and is not open to inspection or review by any owner. And I know that frustrates owners because they're like, well, this is our association and this attorney is representing us in a sense. The attorney is representing the corporation, but through the board in essence, because the board is the attorney's contact. And the attorney-client privilege is a highly protected privilege. And owners are not entitled to see the communications back and forth between the attorney and the board, which is frustrating, but that's how it works with the attorney-client stuff. Now, what an owner can do, and it's not quite the same thing, so the owner cannot demand to see the attorney's opinion because, again, that's privileged. Now, what an owner could do is the owner could make a demand or send an inquiry about that issue and demand that he or she, the owner, be provided a substantive written response to their inquiry. And that's under the Florida Condominium Act. And the association within 30 days must either provide the substantive response or must provide an answer saying that this matter, that they're seeking a legal opinion on that matter, in which case the owner gets a substantive. Now, the owner is not entitled to what the opinion is, but within 60 days, the owner would be entitled to a substantive response, or the association can say, we're going to go to the division, to the state and ask them for advice, in which case the owner is entitled to a substantive response from the association within 10 days of the association receiving that advice. So at least that way, the owner can demand and get some type of substantive response to whatever the issue may be, the penalty or the consequence if the association does not provide a substantive response in a timely way to that certified mail inquiry is that if there's any kind of litigation arising out of that issue or any kind of arbitration, the association would be precluded from recovering its attorney's fees because it failed to give a substantive response. Now, that's may not satisfy your need to to hear what the lawyer said, or why the lawyer said it, or what question was posed to the lawyer. But at least you can pose your own inquiry and at least get a substantive response.
And when Peter's talking substantive response, he's meaning that they're going to
not just yes or no response.
Right.
Something substantive.
It's going to point to some sort of code, some sort of document issue,
some sort of explanation,
something that's going to have some support for it, other than our attorney said so. It would have to have some additional information in it to lend some credence to the answer. But and the good thing about that, as Peter said, is that you at least can craft the question so that the question that is being asked the question you want to ask is being asked, that it's not being, because the attorneys sometimes are left in the dark on this. The board is their contact. The board asks them a question that's not necessarily the same as what the issue is, or they leave out some important stuff. So that they get the answer they want. Frankly, that's also why sometimes the information that's given back from the attorney, because the attorneys a lot of times, like Peter does from time to time, will tell you, here are the issues on both sides. Here is what somebody could argue, and here is what, like this issue that we had earlier with Eric on the fence issue, right? The board member says, calls and says, hey, Peter, we want to change the fence from from chain link to this really nice solid fence that we've got here, and what's the issue? And Peter says, well, you might be able to do it if it significantly extends the life of the asset, and you don't have to replace it as often, and yada yada yada, like Peter said. Or and then he probably, just like Peter always says, but if it's going to be questionable, which this might be, you probably should go to an owner vote. Well, the board member's not always going to tell you that second part. They're going to say, yeah, the attorney said we could probably do this because such and such and such and such. And all of these things, as many of you know, and listening to the program and listen to Peter for the years, some of these things are just not always that clear cut, And so it's a good idea to, at least if you need an answer, you want an answer, Roberta, is to frame the question so that, you get an answer. I encourage you to ask some of those questions on here. We don't have your documents, but we can sometimes give you, what both sides of the issue might be, too, so that you'd at least understand. Because some of these things, to be truthful, some of these things are relatively routine. And the attorney and the property manager does know the answer, because the attorney's dealt with this problem, half a dozen times, either here or in another association. And they've told them, look, you can't do it because of such and such, or you can do it because of such and such.
And to be entitled to the substantive response, your inquiry must be sent to the association by certified mail. So just an email inquiry or a regular mail inquiry doesn't rise to the level of requiring them to respond. So it needs to be a certified mail inquiry to trigger their obligation to respond.
Yeah, and Roberta, you should never just take that the attorney said so. It always should be the CPA said so, never just the attorney said so.
Okay, thank you.
You're welcome.
You're welcome.
Thanks a lot. That does happen a lot, Peter. Not that they say the CPA said so, but that they, it is, especially with property managers, commonly deal with these issues.
And I know it can be frustrating for owners.
Oh yeah.
It is, but the attorney-client, again, unfortunately or fortunately, depending on how you look at it, I mean, just the attorney-client relationship, and it's a highly protected relationship that boards, quite frankly, just should not waive, because once they provide an owner with a copy of that opinion letter or whatever, it then waives the privilege,
Right.
Which, quite frankly, is not to the benefit of the association's interest.
No.
Because there's a reason why the attorney in those letters needs the freedom, to say what he or she needs to say,
Right.
when they're speaking to their client, either verbally or in writing.
Well, and the funny thing about it is that let's face it, board members make mistakes, and those mistakes can be extremely costly. And yes, and a lot of times that action is going to be brought by a homeowner, a unit owner. And so I think that you made the key statement is that you represent the corporation. And so as a result, you're trying to protect the corporation from damage. The board could have caused that damage, but it's still your job to do some damage control and protect the association from, because the corporation, if it ends up getting fined or having action taken against it, everybody's going to pay for that. Everybody's going to pay for the legal fees. That's why I think it's kind of interesting, but that the association won't get its legal fees covered. Well, but the board probably doesn't care because everybody's going to pay for it anyway, including the people that are probably arguing with them. So it's kind of a weird situation, these things, but and that's what people don't realize, that sometimes it's like major corporations, they have lawsuits brought against them by shareholders. Well, the attorneys advising the corporation, they even though, the company is owned by the shareholders, they have a responsibility to protect the corporation and all of the shareholders from, going out of business, financial ruin, excessive penalties, and everything else. Doesn't mean they can break the law, but, it does mean that there's some issues that may need to be discussed that you just don't want the general public hearing about, So and that's important, because it can make a big difference, and give somebody a leg up in the process. So it's interesting that I know how frustrating it is, though. It's frustrating for me too, but well, the attorney told me to. Okay, so I believe it. Who's the attorney? Oh, yeah, I believe it. But anyway, so what a little bit. I know how we deal on our side. If I have to give an opinion, from time to time, I have to give tax opinions on a tax issue, and so it is a little different process. Do you guys have? I mean, I assume you do, and I may not.
Every firm does it different. I really
Yeah.
can't get into what we do, but every firm treats opinion letters in their own way.
Yeah.
So
so usually they can, you've got to look at some of those things, and it because if you work for a firm, you're potentially putting the firm on the line at that point, for that action. So that's why it does depend, but I know it's kind of strange. I know some of the firms have a process that only select people can actually sign those legal opinions. Others, it's more loose that each partner is allowed to make their own determination and that kind of thing. But it is a much more formal process, so it's a lot easier sometimes to just get an answer from an attorney about a question, especially if it's not something where you're getting ready to go to court, that kind of thing.
mhm.
And in your situation, you'd have the client's documents, so you'd be familiar with at least what the documents say, and have some better idea what what room they have to change or make answers, or make a change in their answer, I should say. Anyway, the good questions today. I like some of this, and I know Roberta said, well, it's not what we were talking about, but that's okay. That's why we're here. 220-9788, 220-WSTU is the number. And we're here to answer those kind of questions, even if we're talking about another subject. I can jump down off my soapbox and get right back on again, as Peter knows. So it's not hard for me.
Well, you need that soapbox just to reach the top shelf anyway.
That I do. That I
Most
do.
things.
I do. I truly do. So, but I did, and I think I made my point on it. But it does bother me, and I've been dealing with that issue. We have a relatively sophisticated um, system for our technology across the board, and we utilize that technology, but it is fairly, we have a fairly sophisticated system, and yet we still have to deal with these problems. We still had to deal with, and the hackers are getting much more sophisticated. It's amazing. A friend of mine who owns a technology company, he and another one of his people were just at a seminar recently that was basically taught by a couple ex-military, and what is making a lot of this so difficult is that you hear all this stuff. It is the Russians. It's the Russians and the Chinese and the North Koreans. But there's select groups that they're basically they're military sponsored hackers is what they are, and they have access to equipment that's been developed by that military or by others, and they're paid by they're part of the military complex of Russia and China and North Korea, and their job is to go in and cause as much havoc as they possibly can. It's not the money. They're trying to bring down a business or cause a business to be shut down, and that's and those are happening every single day. In fact, when I had a problem, it was funny because the guy I was talking to, he kept saying, the one guy I was talking to him on the phone, the one guy kept saying he, and the other guy says, "Boy, you're being real chauvinistic." He says, "This could be a woman doing this," and the other guy says, "Nah, just picture some fat Russian sitting in a chair, doing it."
Lovely.
Yeah, but it's true that these are a lot of this stuff comes from state-sponsored activities, because our system and this law is an example. We are becoming technology is being placed in and becoming entwined in our systems and becoming so important to how we do business that that it's gotten to the point that if you can disrupt that, whether it's cell phones or computers or servers or emails or whatever, it takes those businesses down. And of course, mostly a lot of the big companies are targets, like Amazon and all of that. They deal with this every single day. But even the smaller businesses are like mine are dealing with it, and it's interesting because they do these things like these ransomware things, and the other thing that they do is basically they overload your system so that you can't provide any response. You can't, your system just shuts down, because if you got 40,000 email inquiries instantaneously, your business, you're not equipped for that. So the system says, I can't handle it. And it shuts itself down. And now you're out of business. You can't. There's a lot of those things going on in the technology world. And for the board members, if they're going to get into that world through this requirement, they just need to be aware of what's happening and make sure they they protect themselves on that. Other than some of the things that we're talking about. One of the things, going back to Eric's original question on the common property issue and material alterations, is I think probably again is that some of the things that are allowed that were not taken into consideration is also has to do with certain communication things, like we've talked about, and energy efficiency issues. So, for example, one of the associations out in Palm City recently replaced all of their roofs. I think they had tile roofs or shingle roofs. They replaced them all with metal roofs. Now, certainly that is a material alteration. That metal roof looks completely different than
Yes.
shingle or tile. But they were able to do that because of the energy efficiency and because of the hurricane protection, and because of the maintenance. They don't have to do the maintenance on it. So they were kind of able to do all of that, even though that's a fairly significant change. But they had 3 or 4 different areas, and there's no question that the life of the asset is extended. A metal roof needs far less work than any other kind of roof, and it does provide a significant amount of energy savings because of the reflective capabilities of the roof. So those 2 things alone were big deals, and probably would have kept it from somebody from being able to challenge it. But so there's some of those kind of things out there too, Peter, right? That people need to consider.
Yeah, and then even the cases sometimes are somewhat schizophrenic. Against some of these cases are appellate court cases, which obviously have a lot more precedential value than just an arbitration case. But I know there was, if my memory serves me correctly, there was one district appellate case where an association went from a cedar shake shingle roof, which are hard to maintain in Florida,
right?
The cedar shakes, to a tile, I think it was barrel tile, but that was held to be an alteration. Yet there was an arbitration case where they went from black, I believe it was black window trim or paint, to white, with the theory that the white reflects the heat, was more energy, efficient for the building, and that was held to be okay because, so I'm not going to say the cases are always 100% consistent, which is why sometimes, in the absence of it, being absolutely clear cut, like with the case with the seawall or the rock jetty, where the building was having an erosion problem. Sometimes it's just not easy to make the call. It really depends upon the facts and circumstances. Do you have engineering backing you up, saying, that you really should not do this because it's this is causing stress on the building, or this is unsafe, or whatever. So that's why it's hard for me to give a definitive sometimes in these. Again, some are easier than others, but others it becomes a little more difficult to try to in essence guess, which is what we're doing sometimes. If it got to a courtroom or to an arbitration, which way would they go?
Well, and plus
alteration versus maintenance or protection. Again, the easy cases are where it's needed because of a code, or it's clearly, it's very clear cut where what you're doing is is necessary to protect the building or the residents. Some of the other ones are more difficult.
Well, and plus it does make a difference too what appellate court you're in. I mean, if the appellate courts are in disagreement, you don't know for sure.
Well, that's true. Sometimes the districts will disagree,
right,
with each other.
So then you got to deal with that whole thing because and the state may be even taking a position that they've won in one appellate district and have lost in another appellate district, and they're going to continue to take that the position they want to take until such time as the Supreme Court decides. So it is complicated especially when you're relying on court cases, unless they're really Supreme Court cases, Florida Supreme Court cases. It's hard to know for sure. But it could be applied differently depending upon what appellate district you're in too. So that's why sometimes people say, well, I was over in Tampa and, we did this over in Tampa. Well, yeah, you can do that over in Tampa. You can't do it here in West Palm. So anyway, it's something to be thinking about. We appreciate the questions and we appreciate people joining us here on Condo Solutions. We're here every Monday from 9 to 10 o'clock right here on WSTU Digital 1450, Martin County's Heritage Station.